Look at any major courthouse built between 1850 and 1900. The columns are 40 feet tall. The rotunda could seat 1,000 people. The marble floors stretch further than most city blocks. And the official record tells us this building was constructed to serve a frontier town of perhaps 800 residents. 800 people. That number sits there and it doesn't move. This video explores historical interpretations and unanswered questions found in existing records. It does not present definitive conclusions. But let's stay with that number for a moment, because the building we're describing isn't an exception. It isn't the civic pride of one ambitious mayor in one unusual town. Walk the county seat records across the American Midwest in the 1870s. Walk the administrative centers of newly incorporated British territories in the same decade. What you find repeatedly is the same structural logic. Buildings sized for populations that won't arrive for another 30, sometimes 50 years. Legal infrastructure. Courthouses, land registry halls, chancery buildings, municipal archives, constructed at a scale that presupposes a civilization already in motion. The standard explanation is straightforward and widely accepted. Governments, the argument goes, built for the future. They anticipated growth. They understood that civic structures take decades to complete and that a building raised in 1870 must still be standing and functional in 1920. This is rational planning. It is, historians largely agree, simply what forward-thinking governance looks like. That explanation is coherent. It holds together until you start to measure. Not metaphorically measure. Literally measure. Square footage per capita. Legal processing capacity per recorded case. Vault storage volume relative to the number of registered land deeds in the year of construction. When researchers have gone through the trouble of running these numbers against population records and caseload archives from the same period, something uncomfortable emerges. The gap isn't the kind you'd expect from ambitious planning. It isn't 20% oversized or even 50%. In documented cases across multiple states and territories, the legal infrastructure built during this period was sized to process volumes of legal activity that the region would not generate for generations, and in some cases, never did generate at all. That's the first discomfort, and it's a small one on its own. But legal architecture isn't just about floor space. It's about systems. A courthouse is not merely a large room. It is a machine, and the machine requires parts. Record-keeping frameworks, filing taxonomies, title chain systems, notarial protocols, jurisdictional hierarchies laid out in advance of any disputes that would require them. What the historical record shows, in territory after territory incorporated during the mid to late 19th century, is that these systems did not develop organically in response to legal need. They arrived complete, or very close to complete. Take land registry systems as one example. In frontier territories where formal land ownership was still being negotiated, where surveys were incomplete, where indigenous land claims were unresolved, where the population was sparse and mobile, the administrative architecture for recording property transfer was already formalized. Not roughly formalized, precisely formalized. With categories, with numbering systems, with procedural chains that presuppose not just future land sales but a very specific kind of future land sale. A type already encoded, already anticipated. Some researchers suggest this points to template adoption, that newly formed jurisdictions simply copied legal frameworks wholesale from established ones, which would explain why the systems appear more developed than the local conditions would seem to require. This is a reasonable interpretation, and it has real evidentiary support. British colonial administrative frameworks, for instance, were routinely transferred to new territories as a package. But template adoption carries its own questions. If the systems were copied, the question becomes, copied from what? The source frameworks, the ones being reproduced across territories in the 1860s and 1870s, were not simple. They were not the kind of legal architecture that develops in a decade. Common law traditions take centuries to formalize. Title chain protocols require generations of dispute, resolution, and codification before they become elegant. Yet what we see repeatedly is new jurisdictions and regions with almost no formal legal history immediately operating with systems of considerable sophistication. The official record attributes this to legal inheritance, to the transmission of English common law, to the expertise of trained lawyers who carried frameworks with them as they moved. And again, this is not an unreasonable explanation. But there is a scale problem. The scale problem is this: legal inheritance explains the framework. It does not straightforwardly explain the physical infrastructure. A legal tradition can be transmitted in books, in trained minds, in correspondence. It does not require 40-foot ceilings. It does not require vaulted archive rooms built from dressed stone, sized to hold decades of documents that do not yet exist. The transmission of legal knowledge and the physical construction of institutional buildings at extraordinary scale are two separate phenomena, and the historical record largely treats them as one. When you separate them, you find that the building programs and the intellectual inheritance don't always sync. In several documented cases, the physical infrastructure appears to precede the formal legal adoption of the frameworks it was ostensibly built to house. The building arrives first. The system arrives second. Or they arrive simultaneously, which is itself unusual if we take seriously the idea that these were frontier constructions responding to local conditions. This is not a small timing anomaly. This is a pattern that repeats across geography, across political jurisdiction, across the Atlantic. And the pattern is consistent in one specific way. It is always the legal and administrative layer that shows this overpreparation. Not housing. Not commercial buildings. Not churches, schools, or hospitals, at least not to the same degree. It is specifically the architecture of governance, jurisdiction, and record that appears sized for something larger than what the record tells us was there. Which raises a question that the standard framework handles only partially. What, exactly, was the legal infrastructure being built for? The Midwest is a useful starting point precisely because it is so well documented. The territorial records exist. The census figures exist. The construction contracts, where they survive, exist. And so the gap between what was built and what the population warranted is not a matter of interpretation. It is a matter of arithmetic. But the Midwest is not where this pattern is most striking. Move east. Move to the established cities of the American seaboard, where the argument about frontier ambition no longer applies. Philadelphia City Hall, to take one example that historians have written about extensively, was begun in 1871. Construction would continue for 30 years. When it was finally complete, it was the largest occupied building in the world by some measures. A structure housing legal, administrative, and governmental functions at a scale that, at the time of its groundbreaking, the city's official caseload and administrative volume did not come close to requiring. The standard explanation here is civic competition, architectural ambition, and the political economy of public construction contracts. These are real forces. They genuinely shaped 19th century building programs. But they explain the ambition. They don't fully explain the specificity. Philadelphia City Hall was not simply large. It was precisely configured for legal processing. The distribution of courtrooms, the placement of record vaults, the routing of administrative corridors, these were not decorative decisions. They were functional ones. And the functions they were optimized for suggest an anticipated volume of legal activity that the city, even at its peak decades later, would only partially approach. Some researchers who have examined the original architectural briefs note that the building's internal organization reflects assumptions about case throughput and document volume that seem, in retrospect, to have been drawn from somewhere other than Philadelphia's actual legal history at the time of design. That phrase, drawn from somewhere other than local conditions, is worth sitting with, because it appears again in the United Kingdom. The Victorian era in Britain produced an extraordinary quantity of civic legal architecture. Quarter sessions courthouses, assizes buildings, county record offices. The official explanation again is coherent. Britain was industrializing rapidly, urban populations were growing, and the legal system was under genuine pressure to expand its physical capacity. The Judicature Acts of the 1870s reorganized the entire English court structure, and new buildings were a natural administrative response. All of this is accurate. And yet, when researchers map the construction timeline against the population data and the actual recorded caseload figures, the same structural anomaly appears. Buildings consistently sized above demonstrable need. Not modestly above, significantly above. Record storage capacity built to hold archives that would have required, at the rate of document generation actually occurring at the time, somewhere between 40 and 80 years to fill. In some county record offices that still survive and have been studied, the original shelving systems, installed at construction, were designed for a density of holdings that the office didn't reach until well into the 20th century. This is infrastructure built for a future it could not have reliably predicted, or infrastructure built for a present that the records do not fully reflect. That second possibility is the uncomfortable one, and it's worth being precise about what it implies, and what it does not. It does not imply fabrication. It does not imply that the populations recorded in census data were invented. What it raises, more carefully, is a question about whether the legal and administrative systems being housed in these buildings were designed to serve only the populations that official records describe, or whether they were designed with reference to a broader or pre-existing legal order whose documentary footprint is harder to locate. Some researchers point to what they call administrative continuity, the idea that new governmental systems, when they are established, don't build from nothing. They inherit, they adapt. And sometimes what they inherit is larger and more complex than the founding narrative acknowledges. This is not a radical claim. It is, in fact, the standard account of how legal systems work. Common law is explicitly a system of inheritance and precedent. The question is only whether the physical infrastructure sometimes reflects an inheritance more substantial than the formal record admits. Look at the land title systems of newly admitted American states in the 1840s and 1850s. Ohio, Indiana, Illinois. These states entered the Union with functioning, sophisticated title chain systems already in operation, systems that presuppose decades of prior recorded ownership, dispute resolution, and jurisdictional clarification. In regions where European settlement, by the official record, was measured in years rather than decades, the legal architecture of land ownership was operating at a level of institutional maturity that takes generations to develop organically. The template explanation again covers part of this. Legal frameworks were transferred from the original colonies, from English precedent, from trained practitioners. But template transfer explains doctrine. It does not explain the physical volume of pre-existing recorded instruments. Title chains require prior deeds. Prior deeds require prior transactions. Prior transactions require prior parties, prior dates, prior legal recognition of the land being transacted. In several cases, researchers examining early county deed books have noted that the oldest recorded instruments in newly formed jurisdictions reference prior conveyances, instruments that predate the county's official existence. This is sometimes explained as clerical regularization, as the formalization of informal arrangements made before legal infrastructure existed. That explanation is plausible. It is also, by definition, an acknowledgement that legal activity was occurring before the official legal system existed to record it, which raises quietly the question of what system was recording it before. Infrastructure before demand. Systems before the populations that would use them. Legal frameworks whose physical expression consistently outruns the histories we use to explain them. Across the American frontier, across Victorian Britain, across territory after territory incorporated into expanding administrative orders, the same configuration reappears. Some researchers, looking at this cluster of patterns, have begun to group them under a broader interpretive label. Not as an answer, as a question. That label and what it does and does not mean is where this examination goes next. Tartaria, as it appears in contemporary online research communities, in certain academic adjacent discussions, and increasingly in documentary and investigative media, is not a straightforward term. It does not refer in these contexts to the historical Tartary, the vast geographic designation used by European cartographers from the medieval period through the 18th century to describe the territories stretching from the Caspian Sea to the Pacific. That historical Tartary was real. It appeared on maps. It was referenced in diplomatic correspondence, in travel accounts, in the commercial records of trading companies. It was a genuine geographic and ethnographic category, however loosely defined, used by Europeans to organize their understanding of the Eurasian interior. That is not what is being discussed when researchers today invoke the term in relation to legal architecture, civic infrastructure, or administrative systems. When the label appears in this context, it is functioning differently. It is functioning as an interpretive container, a word that a loose and geographically dispersed community of researchers has begun using to collect a set of observations that don't fit comfortably inside the standard historical narrative. The observations themselves are not invented. The courthouses exist. The scale mismatches exist. The timing anomalies in land registry systems exist. The question is only what to make of them, and Tartaria, in this usage, is less a claim than a gesture toward a class of unanswered questions. It is worth being precise about what this means and what it does not mean. One interpretation, perhaps the most cautious, is that the label reflects nothing more than pattern recognition bias. Human cognition is extraordinarily well adapted to finding structure in noise. When researchers across different regions and different historical periods notice similar anomalies in civic infrastructure, the impulse to group those anomalies under a single explanatory framework is psychologically natural, even when no such framework is warranted. On this reading, Tartaria is a name for a cognitive tendency, not a historical reality. The patterns are real. The interpretation is an artifact of how minds process unexplained data. This interpretation has genuine merit and should not be dismissed. A second interpretation takes the patterns more seriously as historical evidence, while still resisting grand conclusions. On this reading, the scale mismatches and timing anomalies in legal architecture reflect something real about the way administrative systems were transmitted and instantiated in the 19th century, something that the standard narrative of frontier development and colonial template transfer does not fully account for. This interpretation does not require the existence of a hidden civilization. It requires only that the mechanisms of institutional inheritance were more complex, and perhaps more discontinuous, than the textbook account suggests. Jurisdictions inheriting not just legal doctrine but physical infrastructure. Administrative systems arriving not as constructions but as adaptations of something pre-existing. Record-keeping frameworks whose sophistication implies a longer institutional history than the founding dates of the jurisdictions they served. Some researchers in legal history and architectural history have gestured toward versions of this interpretation without using the Tartaria label at all. The label, in this sense, is a popularization, a way of giving a name to a scholarly unease that exists in quieter form in more credentialed discussions. A third interpretation, more speculative and more contested, suggests that the physical and legal infrastructure documented in these anomalies represents evidence of a prior administrative order, not necessarily a civilization in the cinematic sense, not an empire with a capital and a flag, but a distributed system of legal and governmental organization that preceded the political formations we treat as originary. On this reading, what 19th century governments were doing when they built courthouses sized for populations that didn't exist was not planning for the future. They were inheriting from a past they did not fully acknowledge, adapting institutions, buildings, and legal frameworks whose origins preceded their own founding narratives. This interpretation is the one most associated with the Tartaria label as it circulates online. It is also the one that requires the most scrutiny, because it is the one most vulnerable to motivated reasoning, to the selection of evidence that confirms the hypothesis and the dismissal of evidence that complicates it. The anomalies in the record are real. Whether they point toward a prior administrative order, or toward the mundane complexity of institutional inheritance, or toward nothing more than ambitious Victorian construction programs and the occasional clerical irregularity, that question is genuinely open. And that openness is, in its own way, the point. What the Tartaria interpretive framework does at its most useful is force a specific kind of attention onto evidence that might otherwise be absorbed without friction into the standard narrative. The courthouse that was too large. The deed book that referenced a prior conveyance from before the county existed. The record vault built to hold 50 years of documents in a territory with a 10-year legal history. These are not individually earth-shaking anomalies. They can each be explained. But the explanations are local. They address each anomaly individually in isolation without accounting for the consistency of the pattern across geography and across time. That consistency is what the Tartaria label names. Not a civilization. Not a revelation. A consistency that standard explanations handle case by case but have not, as a scholarly matter, addressed as a pattern. There are researchers who find this framing irresponsible, who argue that grouping these anomalies under a single evocative label encourages the kind of totalizing interpretation that evidence of this kind cannot support. This is a fair concern. The history of popular alternative history is littered with cases where genuine anomalies were used as foundations for structures of speculation far beyond what the evidence warranted. The Tartaria discussion, in its less careful iterations, has produced exactly this kind of overreach. But the overreach of some interpretations does not dissolve the underlying observations. The courthouses are still too large. The legal systems are still too mature for the histories assigned to them. The vaults were still built before the documents existed to fill them. These are not conclusions. They are measurements. And measurements, unlike interpretations, don't resolve themselves simply because we decide we're uncomfortable with where they point. What the legal architecture of the 19th century actually reflects, whether rational anticipation, complex institutional inheritance, administrative continuity from something older, or simply the grandiosity of an era that built in stone because stone was how civilizations announced themselves, remains, in the most precise sense of the word, an open record. And open records, by their nature, are still waiting to be read.